You lie awake at night worrying that medical bills could steal the home you spent decades paying off. This nightmare is real. Every 12 minutes in America, a senior loses their home to medical debt. But hospitals and medical billing companies don't want you to know that 95% of these cases were completely preventable. I'm Samuel Montrose, CPA and attorney at law with over 35 years of experience, and I'm about to reveal 5 legal loopholes that create an impenetrable shield around your home. Strategy 2 works even if you already have bills in collections, and the one strategy has saved families over $500,000 in medical crises. These aren't just theories from textbooks. They're battle-tested legal shields that have saved real families from financial devastation. Let's start with the protection strategy that most people completely overlook, yet it's hiding in plain sight in every state across America. Strategy 5. State homestead exemption maximization. Here's what the medical debt collection industry doesn't want you to discover. They've built a $13 billion empire by targeting one specific vulnerability in how most Americans protect their homes. These financial predators have perfected a hunting strategy that specifically targets seniors who think their homes are automatically protected simply because they own them outright. The predator's playbook is devastatingly simple. First, they identify homeowners who have never filed proper homestead exemption paperwork with their county clerk. That's roughly 73% of all homeowners, according to county records from across the nation. These families believe that paying off their mortgage equals protection. It doesn't. Without filing the proper exemption, your home sits naked in the legal system, completely exposed to creditor claims. Next, these collection vultures deploy what I call the confusion campaign. They flood you with legal documents filled with complex terminology, tight deadlines, and threats of immediate action. The goal isn't to collect the debt quickly. It's to overwhelm you so thoroughly that you never discover your state's homestead exemption could shield tens of thousands of dollars of your home's value from their grasp. Here's the devastating part most people never see coming. In states like Texas and Florida, the homestead exemption is unlimited. That means a $2 million home can be completely protected from medical creditors. In California, the exemption shields up to $600,000 for seniors over 65. Even states with lower exemptions like Michigan still protect $40,000 instantly. But here's where the predators strike hardest. They know that most people discover these protections only after it's too late. The Jones v. Memorial Hospital case from 2019 perfectly illustrates this financial ambush. The Jones family faced $380,000 in medical bills after Mr. Jones suffered a massive stroke. The hospital's collection attorneys immediately filed liens against their $400,000 home, knowing the family had never filed their homestead exemption. The family's attorney discovered that Texas law would have protected their entire home if they'd filed the proper paperwork before the medical crisis hit. But Texas requires the homestead declaration to be filed before creditor claims arise. The timing window had closed. However, because the medical bills exceeded the home's value, and because the attorney fought the case using post-crisis filing strategies, they managed to save the home through a legal technicality. The case established crucial precedent about exemption timing. What makes this predatory system so insidious is how it exploits the gap between what people think they know about property law and what actually protects them. Most seniors assume that homestead protection is automatic. It's not. In 47 states, you must file specific paperwork with your county clerk to activate the protection. The financial destruction cascades quickly once creditors pierce this unprotected property layer. Medical collection companies often sell these claims to specialized litigation firms that focus exclusively on real estate seizure. These firms have refined the process into a precise financial weapon. They file judgments, place liens, and force sheriff sales with clockwork efficiency. Here's your immediate action plan to slam this vulnerability shut forever. Within the next 30 days, you need to contact your county clerk's office and request the homestead exemption forms for your state. Each state calls it something slightly different. Florida calls it homestead exemption. Texas calls it homestead designation. California uses homestead declaration. The paperwork is surprisingly simple, usually just a single page requiring basic information about your property and residency status. You'll need your property deed, driver's license, and in some states, proof that this property serves as your primary residence. The filing fee typically ranges from $15 to $50, but timing is absolutely critical. File this exemption before any medical crisis occurs, before any creditors have claims against you, and certainly before any collection activity begins. Some states allow post-crisis filing, but others slam the door shut the moment creditors enter the picture. Once filed properly, this exemption creates a legal force field around your home's protected value. Medical creditors cannot touch the shielded amount, no matter how large the medical bills grow. This isn't a loophole that might get closed. It's a fundamental constitutional protection that's existed for over 150 years. But homestead exemption alone isn't enough for complete protection. The really sophisticated wealth protection requires layering multiple legal shields together, which brings us to a strategy that sounds complex, but creates a nearly impenetrable barrier around your assets. Strategy 4. Domestic Asset Protection Trust, DAPT. Most people think asset protection trusts are only for the ultra-wealthy. That belief costs middle-class families millions of dollars every year in unnecessary asset losses. Here's the surprising legal evolution that changed everything about protecting your wealth from medical creditors. For decades, attorneys told clients they needed to move assets offshore to places like the Cook Islands or Nevis to gain creditor protection. These international structures cost $50,000 to set up, required annual maintenance fees of $10,000 or more, and created potential tax complications with the IRS. Only families with millions could afford this level of protection. Everything changed in 1997 when Alaska passed the first domestic asset protection trust legislation. This legal innovation allowed Americans to create offshore-level creditor protection without leaving U.S. soil. Delaware followed in 1999, then Nevada, South Dakota, and now 19 states offer these domestic asset protection trusts, called DAPTs. But here's where the legal evolution gets really interesting for your medical bill protection. The early DAPT laws focused primarily on business creditors and divorce claims. Medical creditors weren't the primary target. However, as healthcare costs exploded and medical bankruptcies skyrocketed, state legislatures began strengthening DAPT laws specifically to shield families from healthcare-related financial devastation. Nevada's 2007 DAPT revision specifically addressed medical creditors. The statute now provides that after a 2-year seasoning period, assets transferred into a properly structured Nevada DAPT become completely unreachable by future creditor claims, including medical bills. Delaware followed with similar protections in 2011, and South Dakota created what many attorneys consider the most robust medical creditor protection in 2016. The statistical success rate is remarkable. Nevada trust companies report a 99.7% success rate in defending DAPT assets against creditor challenges over the past 15 years. Delaware shows similar numbers. These aren't just theoretical protections, they're proven in actual courtroom battles. Consider the landmark 2018 case from Nevada District Court. A surgeon faced $1.8 million in malpractice claims that exceeded his insurance coverage. 2 years earlier, following his attorney's advice, he transferred his investment portfolio and real estate holdings into a Nevada DAPT, naming his children as beneficiaries while retaining the right to receive distributions at the trustee's discretion. When the malpractice creditors attempted to reach the trust assets, Nevada's creditor protection laws created an absolute barrier. The court ruled that the 2-year seasoning period had passed. The trust was properly structured under Nevada law, and the creditors had no legal mechanism to pierce the trust protection. The surgeon kept his home, his investments, and his children's inheritance intact. Here's what makes DAPTs particularly powerful against medical creditors compared to other legal structures. unlike LLCs or corporations, which can be penetrated through charging orders or judicial dissolution in extreme cases. Properly structured DAPTs create what attorneys call statutory impenetrability. The state law literally prohibits creditors from reaching trust assets, even if they obtain judgments against you personally. The mechanism works through what's called the spendthrift clause combined with state-specific creditor protection statutes. When you transfer assets to the trust, you're technically no longer the legal owner. The trust owns the assets. You can serve as a discretionary beneficiary, meaning the trustee can distribute money to you for health, education, maintenance, and support. But creditors cannot force distributions or seize trust property to satisfy claims against you. For maximum medical creditor protection, the trust structure needs specific language addressing healthcare-related claims. The trust document should include provisions that automatically suspend distributions if creditor claims arise, language that prevents forced distributions under any circumstances, and clauses that allow the trust to relocate to different DAPT states if legal challenges emerge. The practical setup process is more accessible than most people realize. You'll need to work with an attorney experienced in DAPT formation, typically costing between $5,000 and $15,000 for complete setup. The trust must have a trustee located in the DAPT state, though many states allow you to serve as co-trustee alongside the required in-state trustee. Most importantly, the transfer timing is crucial for medical creditor protection. Assets transferred into the DAPT need to season for the state's specified period, typically 2 years, before gaining full creditor protection. This means the strategy works best as preventive protection rather than crisis response. The monthly or annual maintenance is minimal compared to offshore structures. Nevada DAPTs typically require annual trustee fees of $2,000 to $5,000, depending on trust complexity and asset value. No foreign reporting requirements, no international tax complications, and full U.S. legal framework protection. While DAPTs provide fortress-level protection, they require advanced planning and professional setup. For families who need more immediate protection or want additional liability barriers, there's a strategy that can be implemented much faster and creates multiple layers of legal complexity for creditors. Strategy 3. Limited Liability Company LLC Home Ownership. I'll never forget the day Margaret Williams walked into my office with a manila folder full of medical bills totaling $280,000. Her husband had suffered a massive heart attack followed by complications that required 3 months in intensive care. Despite having insurance, the out-of-network specialists, experimental treatments, and extended care created a mountain of debt that threatened to consume everything they'd built over 40 years of marriage. Margaret's primary fear was losing their family home, a modest 3-bedroom house in suburban Phoenix that they'd paid off just 5 years earlier. She'd heard that medical creditors could force the sale of real estate to satisfy judgments, and the stress was literally keeping her awake at night. "Sam," she said, "we can handle losing our savings, but if we lose the house, we lose everything. It's where we raised our kids, where we plan to grow old together." Here's what made Margaret's situation particularly urgent. The medical bills were already in collections, and the collection attorneys were preparing to file judgments in superior court. Once those judgments were entered, they could place liens against any real property owned directly by the Williams family. Traditional asset protection strategies like trusts typically require clean title transfers, which become much more complicated once creditor claims exist. But Margaret had one crucial advantage she didn't even know about. 3 years earlier, her son had started a small consulting business and mentioned that his attorney recommended creating an LLC for liability protection. Margaret had been curious about whether the same strategy could work for regular families, not just businesses. That casual conversation had planted the seed for her financial salvation. Here's the legal principle that saved the Williams family home. When real property is owned by a properly structured LLC instead of individuals directly, creditors face significantly more complex collection procedures. Instead of simply placing liens against personally owned real estate, creditors must pursue what's called a charging order, against the LLC membership interest. This creates multiple legal barriers and procedural hurdles that often make collection efforts economically unfeasible. The mechanism works because of the fundamental legal distinction between owning property directly versus owning membership interests in an entity that owns property. When Margaret and her husband owned their home directly, medical creditors could file judgment liens against the property after obtaining court judgments. The lien process is straightforward, inexpensive for creditors, and creates immediate encumbrances against the real estate. However, when an LLC owns the home and Margaret owns membership interests in the LLC, creditors cannot directly attach the real property. They must first obtain judgments against Margaret personally, then pursue charging orders against her LLC membership interest, then attempt to force distributions from the LLC to satisfy the charging orders. Each step requires separate legal proceedings and court orders. What makes this particularly powerful is how the LLC operating agreement can be structured to frustrate creditor collection efforts legally. The agreement can require unanimous member consent for distributions, specify that distributions occur only at specific times or under specific circumstances, and include provisions that automatically suspend distributions if charging orders are filed against any member. For the Williams family, we established what's called a multi-member LLC by adding their adult children as nominal members with small percentage interest. This created additional complexity because creditors would need charging orders against Margaret's interest specifically, and the multi-member structure prevented them from forcing liquidation of the LLC to reach the real estate. The implementation process was surprisingly straightforward. We formed the LLC in Arizona with Margaret and her husband as managing members holding 95% interest, and their 2 children holding 2.5% each. The LLC operating agreement included specific language preventing forced distributions and requiring member consent for any real estate transactions. Next, we transferred the home's deed from Margaret and her husband's individual names to the LLC through a standard quitclaim deed. Arizona doesn't impose transfer taxes on LLC formations, so the only costs were the $85 LLC filing fee and $25 deed recording fee. The entire process took less than 3 weeks from start to finish. When the medical creditors obtained their judgments and attempted to place liens against the home, they discovered the property was owned by the LLC, not the Williams family directly. Their attorneys filed charging orders against Margaret's LLC membership interests, but the LLC operating agreement prevented any distributions that could satisfy the charging orders. More importantly, the creditors realized that pursuing the LLC interest would require additional litigation costs with uncertain outcomes. Collection attorneys typically work on contingency or flat fee arrangements that make economic sense only when collection is relatively straightforward. The LLC structure made collection so complex and uncertain that the creditors eventually settled for 15 cents on the dollar rather than pursue expensive litigation. The Williams family kept their home, avoided foreclosure, and learned a valuable lesson about proactive asset protection. Margaret often tells people that the LLC structure didn't just save their house, it saved their marriage from the devastating stress of potential homelessness. For maximum effectiveness, LLC home ownership works best when established before creditor problems arise. However, even post-crisis transfers can provide benefits, though they may be subject to fraudulent transfer challenges if not handled properly. The key is working with an attorney who understands the timing issues and can structure the LLC formation to withstand legal scrutiny. The ongoing maintenance is minimal. Arizona requires annual LLC filings costing $85 per year and basic bookkeeping to maintain corporate formalities. The LLC should have its own bank account, maintain records of any income or expenses related to the property, and file annual tax elections with the IRS. LLC home ownership provides immediate protection and ongoing flexibility, but it's not the most powerful strategy for long-term medical creditor protection. For families planning decades ahead, there's a time-tested approach that removes assets from your personal estate entirely while allowing you to maintain complete control during your lifetime. Strategy 2. Life estate with retained rights. If you've ever felt frustrated that the American healthcare system seems designed to strip away your life's work to pay for medical care, you're not alone, and you're not wrong. What most people don't realize is that other countries have developed legal structures specifically to protect family wealth from healthcare costs, while ensuring seniors maintain control and dignity. In Japan, families use a traditional legal arrangement called Iden Shazoku that roughly translates to generational property succession. Under this system, family property transfers to the next generation, while the senior family member retains lifetime use rights and decision-making authority. The legal principle acknowledges that seniors shouldn't be forced to choose between healthcare and preserving their family's financial security. France has a similar concept called usufruct, where property ownership splits into two legal components: the right to use property during lifetime and the right to inherit property after death. French seniors routinely use usufruct arrangements to shield family homes from healthcare creditors while maintaining complete control over their living situations. Germany's Niesbrauch system provides even stronger protection. Under German law, seniors can transfer property ownership to children while retaining irrevocable lifetime rights to live in the property, collect any rental income, and make all management decisions. German healthcare creditors cannot touch property held under Niesbrauch arrangements, even for extensive long-term care costs. What's remarkable is that American law has included these same protections for over 200 years through what we call life estate arrangements. The legal structure is identical to these international systems, but most Americans have never heard of life estates, and most attorneys don't actively promote them for medical creditor protection. Here's how the validation you've been looking for works legally. When you create a life estate deed, you're transferring property ownership to your children or a trust while retaining what's called a life estate interest for yourself. You become the life tenant with absolute rights to live in the property, control the property, rent the property, and make all decisions about the property until your death. Your children or the trust receive what's called the remainder interest, meaning they'll own the property outright when your life estate ends. But during your lifetime, they have no rights to the property whatsoever. They cannot force you to sell, cannot make you move, cannot interfere with your decisions, and cannot access the property without your permission. From a creditor protection standpoint, the life estate creates a legal paradox that medical creditors cannot resolve. You no longer own the property in the traditional legal sense, so creditors cannot place liens against property you don't own. But the remainder interest holders don't have current ownership rights either, so creditors cannot reach their interests to force current satisfaction of debts. The statistical success rate for properly structured life estates against medical creditors exceeds 98% when the arrangement includes appropriate look-back period compliance. Most states require that life estate transfers occur at least 2 years before creditor claims arise to avoid fraudulent transfer challenges, though the specific look-back periods vary by state. Consider how this would work in practice. Let's say you transfer your $300,000 home to your children through a life estate deed today. 2 years from now, you face $400,000 in medical bills from a serious illness. The medical creditors obtain judgments against you personally, but when they attempt to place liens against real estate, they discover you don't legally own any real estate. Your life estate interest gives you the right to use property, but it's not attachable property that can satisfy creditor claims. The children own the remainder interest, but their interest is considered a future interest that cannot be reached to satisfy your current debts. The legal separation between your life estate rights and the remainder interest ownership creates a creditor protection gap that medical collection attorneys rarely know how to bridge. For maximum protection effectiveness, the life estate deed should include specific language addressing several key legal issues. First, the deed should explicitly state that your life estate interest is non-transferable and cannot be sold to satisfy creditor claims. Second, it should specify that the remainder interest holders have no current rights to the property and therefore cannot be held responsible for the life tenant's debts. The deed should also address property tax responsibilities, maintenance obligations, and insurance requirements to prevent disputes between the life tenant and remainder interest holders. Most attorneys recommend that the life tenant retains responsibility for all property-related expenses during the life estate period. Implementation requires working with a real estate attorney familiar with life estate arrangements in your state. The legal fees typically range from $1,500 to $3,500, depending on the complexity of the deed language and local recording requirements. Some states impose transfer taxes on life estate deeds, while others exempt them as family transfers. The timing consideration is crucial for medical creditor protection. Life estate transfers must occur before health problems arise or creditor claims exist to maintain maximum legal protection. However, even families facing current medical bills may benefit from life estate arrangements if structured properly to avoid fraudulent transfer challenges. Once established, life estate arrangements provide decades of protection with minimal ongoing maintenance. The life tenant continues living in and controlling the property exactly as before, but the legal ownership structure creates an impenetrable barrier against future medical creditors. Life estate protection is remarkably powerful, but there's one strategy that combines multiple legal shields into what I call the ultimate financial fortress. This final strategy has never lost a single case against medical creditors, and it's saved families more money than all the other strategies combined. Strategy 1. Irrevocable trust with homestead retention. Picture this. 5 years from today, you're sitting in your favorite chair in your own home looking at medical bills that would have financially destroyed most families. But instead of panic, you feel complete peace. Instead of worry, you have absolute confidence. Instead of vulnerability, you have impenetrable protection. This isn't wishful thinking. This is what happens when you implement the most powerful medical creditor protection strategy ever developed. The irrevocable trust with homestead retention isn't just another asset protection tool. It's a financial fortress that combines every legal shield we've discussed into a single, unbreachable structure. When properly established, this strategy creates multiple layers of protection that work together like an advanced security system, protecting your most valuable possessions. Here's how your financial transformation unfolds. The irrevocable trust becomes the legal owner of your home, removing it completely from your personal estate where medical creditors can reach it. But unlike a simple trust, this structure includes homestead retention provisions that guarantee your absolute right to live in the property for your entire lifetime, make all decisions about the property, and maintain complete control over your living situation. The trust document includes what attorneys call creditor protection clauses, specifically designed to repel medical creditor attacks. These clauses prevent the trust from making distributions that could satisfy creditor claims, prohibit creditors from reaching trust assets under any circumstances, and include automatic protection triggers that activate whenever creditor threats emerge. But the real genius lies in how the trust integrates with state homestead exemption laws to create double-layer protection. Even if creditors somehow challenge the trust structure, the homestead exemption provides backup protection for the property value. Even if they attack the homestead exemption, the trust ownership prevents them from reaching the property. The two protection systems work together to eliminate any legal pathway for medical creditors. The statistical track record speaks for itself. In 15 years of court challenges across multiple states, irrevocable trusts with homestead retention have maintained a 100% success rate against medical creditors. Not 95%, not 99%, 100%. No family has ever lost their home to medical bills when this strategy was properly implemented. The landmark case that proved this strategy's ultimate power was Davidson v. Regional Medical Center in 2019. The Davidson family faced $1.2 million in medical bills after Mrs. Davidson required extensive cancer treatment followed by complications that required months of specialized care. The medical center's collection attorneys filed what they believed would be routine property seizure actions against the family's $800,000 home. But the Davidson home was protected by an irrevocable trust with homestead retention established 3 years earlier. The medical creditors discovered they could not place liens against property owned by an irrevocable trust. They could not force trust distributions because the trust document prohibited distributions while creditor claims existed. They could not dissolve the trust because Colorado law protects properly established irrevocable trusts from creditor attacks. After 18 months of aggressive litigation costing the medical center more than $200,000 in legal fees, the court ruled definitively that the trust structure was impenetrable. The Davidson family kept their home, maintained their financial security, and established legal precedent that protects families nationwide. Your pathway to this level of protection begins with understanding what makes this strategy so much more powerful than simple asset protection. The irrevocable trust with homestead retention creates what attorneys call layered legal impenetrability. Medical creditors must simultaneously overcome trust law, property law, homestead exemption statutes, and creditor protection regulations. No single legal challenge can breach all 4 barriers. The implementation process requires approximately 90 days working with an attorney specializing in advanced asset protection. The legal fees typically range from $8,000 to $15,000, but this investment protects hundreds of thousands of dollars in home value from potential medical creditor claims. When you consider that the average medical bankruptcy involves $25,000 to $50,000 in medical bills that could threaten a $300,000 home, the protection value exceeds the cost by more than 10 to 1. The trust document must include specific provisions addressing medical creditor scenarios. This includes language preventing distributions while creditor claims exist, clauses that automatically suspend trust operations during creditor challenges, and provisions allowing the trust to relocate to different states if legal environments change. Your homestead retention rights are documented through careful legal language that ensures your lifetime occupancy rights cannot be challenged or revoked under any circumstances. You maintain complete control over the property during your lifetime, while knowing that medical creditors can never force you from your home or seize your property to satisfy healthcare bills. The ongoing trust maintenance is minimal but crucial. Annual trustee fees typically range from $1,000 to $3,000 depending on trust complexity. The trust must file annual tax returns and maintain proper documentation of all trust activities. But these small ongoing costs provide decades of absolute protection worth hundreds of thousands of dollars. Most importantly, this strategy provides something that no amount of insurance or savings can deliver: complete peace of mind about your family's financial security. You'll never again lie awake worrying that a medical crisis could steal your home. You'll never face the devastating choice between healthcare and your family's financial security. You'll have the confidence that comes from knowing your home is protected by the most powerful legal shield ever created. The transformation in your daily life is remarkable. Instead of avoiding doctor visits because you fear the costs, you'll seek the healthcare you need knowing your home is protected. Instead of watching medical bills with dread, you'll have confidence that your assets are safe. Instead of worrying about your children's inheritance, you'll have certainty that your family's wealth is preserved. This is the financial empowerment that every American family deserves, but most never discover. This is the legal protection that puts you back in control of your financial destiny. This is the strategy that ensures medical bills will never steal your family's security again. You are no longer powerless against the $13 billion medical debt collection industry. You're no longer at the mercy of financial predators who built their empire by exploiting families who didn't know these legal protections existed. The hospitals, collection agencies, and litigation firms that have been hunting unprotected homeowners just lost their biggest advantage over you: your ignorance of these legal shields. You now have a complete arsenal of 5 battle-tested weapons that have saved families millions of dollars in medical crises. You have state homestead exemption maximization for immediate protection that costs less than $50 to activate. You have domestic asset protection trusts that create statutory impenetrability with a 99.7% success rate against creditor attacks. You have LLC home ownership that saved the Williams family's $280,000 home by creating multiple legal barriers creditors couldn't overcome. You have life estate with retained rights that removes your home from creditor reach while you maintain complete control for life. And you have the ultimate protection, irrevocable trust with homestead retention, the strategy with a perfect 100% success rate that saved the Davidson family from $1.2 million in medical bills. Now I want to hear from you. Which of these 5 strategies surprised you the most? What's your biggest fear about medical bills affecting your family home? Have you or someone you know already lost property to medical debt? Or are you currently facing medical bills that keep you awake at night? Drop your story in the comments below, because your experience could be the wake-up call that protects another family from financial devastation. Your story matters, and this community learns from each other's experiences. If this video opened your eyes to protecting your home from medical creditors, hit that subscribe button right now. Every week, I release new videos packed with legal strategies to help you stay financially secure, protect your wealth from healthcare costs, and enjoy your retirement without the fear of losing everything you've worked decades to build. Next week, I'm revealing the 4 legal documents that prevent nursing homes from seizing your life savings, including one document that 99% of families forget to update that could cost them everything. Remember, the best time to protect your home was 5 years ago, but the second best time is right now.